Right. Again, we're talking about the administration arguing in federal court right now that the president should have a right to deploy the National Guard, even over the objections of states' governors, states' officials, when they believe it is the correct decision to do so. We were just talking to Jacob, Lisa, and Chris about how the government says that there was sustained mob violence in front of the federal building, and that's why they needed to have the National Guard there to restore order. Jacob says that's not true. From his vantage point, it was peaceful. There was not sustained mob violence in front of that building. Is that also what they're arguing in the court documents?
I would say the court documents are closer to what the government lawyer represented in court, but they don't go as far as even his rhetoric did. So, Katie, I'm going to read to you from a declaration submitted by the director of the field office for ICE's enforcement operations in Los Angeles. This is his supplemental declaration, meaning this is the second time he's tried to update the court on what he's seen on the ground. This is what he represented. For example, on June 14th, 2025, the Los Angeles Police Department declared an unlawful assembly outside 300 North Los Angeles Federal Building. That's the federal building that Jacob was referring to, after violent opportunists in the crowd of over 1,000 people, meaning there were violent opportunists in the crowd of over 1,000, but not 1,000 people were violent, began assaulting law enforcement officers with rocks, bricks, bottles, fireworks, and other objects. He then goes on to say one suspect was taken into custody after spitting on a federal protective officer and National Guard members. Protesters also threw red paint on FPS and National Guard members. Without diminishing the violence that is spitting on a law enforcement officer, if he's talking about one person taken into custody, that is a big difference between a sustained and uncontrolled violent mob and the picture that this gentleman is painting here in his sworn declaration to the court.
I think it's so important to have people who are on the ground because it's so hard to tell from the individual images that we get, the still images that we get that show moments in time, which can make it look a lot crazier and hairier than maybe it was on the ground. Then again, we were seeing some cars on fire. Chris, as somebody who's in law enforcement, is there a way to deal with this without the National Guard being deployed?
Routinely, this is dealt with without the National Guard, and certainly without the U.S. Marines, which is unprecedented being used in Los Angeles. So the mutual aid system would have allowed LAPD, which is a sizable and very professional and very capable force, to reach out to their neighboring departments, including LA County Sheriff's Department, including other federal agencies and local partners, going up to the state level with California Highway Patrol. And if all of that collectively wasn't sufficient to suppress this low-level protest, then they can request the governor provide them with National Guard support.
But that didn't happen.
None of it happened. And I will also point to one thing. He highlighted the Whiskey Rebellion, and it's kind of ironic here. A lot of the Patriot movement points to both Shays Rebellion and the Whiskey Rebellion, which pushing back against federal forces. The police enterprise didn't exist at the time of the Whiskey Rebellion. General Washington, then President Washington, was so concerned about this, he led the troops himself so he could mitigate the impact on the fledgling democracy. It was really concerning to him and wanted to make sure that the citizens of this country were represented and protected.
Can we also point out that law enforcement now, especially law enforcement, everywhere really, but especially law enforcement in big cities, they have a lot of high-tech and very militaristic gear. They get a lot of the cast-off from what we contract for build-up on wars or what we contract to use overseas. They're not, a bunch of plainclothes cops with batons or just cops in a uniform without any armor and batons. These are guys that are heavily armored.
I think it's extremely concerning. Lisa and I have talked about this. The militarization of law enforcement, especially federal law enforcement, since this administration has really accelerated. And that's why you see Homeland Security agents and officers and others from across the federal enterprise showing up in tactical gear, a lot of with camouflage, which is really alarming, masked in some cases, conducting more tactical arrests when it's not needed.
Yeah.
I was on an FBI SWAT team for a number of years. They're are cases where somebody is armed and dangerous and you have to take the protective steps, but many of these arrests are certainly not that. But it has been lionized by the DHS secretary, by the AG, and others, director of the FBI. They are demonstrating themselves wearing tactical gear and carrying, heavy weapons.
Elizabeth, let's talk about the context here. The administration is arguing that it is within their rights. It is their duty to do so. They're trying to use some history, as Chris was saying, with Shays Rebellion and the Whiskey Rebellion. Give us context. When has the National Guard been sent into a state over the objections of the governor?
That has been incredibly rare. And let's just point out that the law that the administration is relying on here did not exist during Shays Rebellion and the Whiskey Rebellion. So that's not really a very useful argument on the part of the government. In terms of deploying the Guard to quell civil unrest or enforce the law over the objection of the state's governors, that has not happened since the civil rights era. And those were situations in which state and local authorities were either refusing to protect people, civil rights marchers and activists, African Americans trying to attend school against mob violence, or the state authorities were themselves refusing to enforce federal court orders. That's a very different situation from what we have here, where the LAPD and the LASD have been very much engaged in trying to ensure that the violence that's happening around the margins of these protests is controlled. So this is an extremely different situation from where Guard forces have been deployed in the past and where they should be deployed under the law, which is what's being argued right now in the Ninth Circuit.
So we just want to read this from Judge Bennett, which you just heard a moment ago. He's asking, does the court have any role here? He says, is it your view, this is to the federal government, that if the president or the future president simply invokes the statute, gives no reason for doing it, provides no support for doing, and there is nothing which would appear to a court to justify it, that the court still has no role at all in determining whether the president can use it? And the lawyer for the government, Shoemate, says that's correct, because if the statute is unreviewable, then it's unreviewable. Explain that to me in layman's terms.
Well, the government went even further, because at one point, I think it was Judge Bennett who asked, suppose that the president relied on a justification that isn't even in the law. So not one of these three criteria that exist in the law, but let's say the president says, I'm going to deploy the troops and federalize the National Guard because it's Tuesday. Can the courts review that? And the government attorney said, no review. And under the most robust version of the political question doctrine, which is this theory that the government is relying on, it's a theory that certain determinations are entrusted to the political branches, the president and Congress, and not the courts. Even under the most robust theory, there are exceptions that the courts have recognized, including when the president is acting in bad faith, where he's made an obvious mistake, where his actions are manifestly unauthorized by law, and where he has exceeded a permitted range of honest judgment. That very important exception is set forth in a case that the government attorney had never heard of, despite the fact that the government is here arguing the political question doctrine. So this has just been a remarkable argument so far.